Hello, everyone. We're happy to have you here for our Association Essentials series. We're going to wait just a moment more and then get started. My name's Darren Carter. I'm the Director of Corporate Training for HOA Living, and I'll be sort of hosting today. So it's nice to be here. We are recording this session, so if any of you can't stay the entire session, we will have a recording that you can access. And I'm going to go ahead and get started since it's 12:02. Again, welcome and thank you for taking time to speak with us to be on with us today. We have a couple of just housekeeping items. Upcoming AES sessions. Our next one is March 26th. The topic for that one will be Build a Better Board Meeting. And we're going to have a panel of participants that you'll really enjoy. So make sure you set that on your calendar, March 26th. That'll be at noon Mountain Standard Time again. And that'll be a really good session. So make sure you can come to that session as well. All right, you can access previous topics at hoa.living.com/AES, or you can get that code there on the screen there, and that'll actually take you straight there. But you can actually access our previous AES series and be able to learn on your own time as well. So, all right, just a couple of quick things. Our community manager of the month for HOA Living is Corbin Fritzler. He works with our CAM division, and he was responsive, enthusiastic. He showed great follow through, and he was anxious to get it right. So we're really glad to have him as part of our team. One other quick announcement is our board member of the month. We have a board member of the month that that you can vote for if you want to vote for somebody on your board that goes above and beyond. And in this particular case, it's Michael Cole, who actually works at High Country Estates, and he's dedicated, oversees Water Lotto, works hard to communicate. He's cheerful and approachable, and so we want to congratulate him for all of his hard work on the board in order to receive this board member of the month. So congratulations to Michael. All right, you can nominate an outstanding board member. If you have one that you would like to nominate, please take a quick picture of that code, and we would love to have you nominate people that work hard for your particular board or association, and be able to have them announced at our next AES meeting. So I'll leave that up for just 1 second more if you want to take a picture of that code and make a vote right now. All right. You can connect with us on social media. There's all of our Instagram, Facebook, Twitter, and LinkedIn accounts. Our Community Scoop, watch for our next monthly Community Scoop e-newsletter. You can share that with your homeowners, and past editions are available on our website. Also, our website portal is just hoaliving.com, or you can access all of the AES, the newsletter, and all of those other things. And then we are on YouTube as well. You can just search hoaliving.com, or just HOA Living, sorry, and it'll come up with our YouTube videos as well of our past AES sessions and other informative videos. All right, let's get into the meat of our discussion today. Governing documents is what we're talking about, everybody's favorite topic, and we're going to go ahead and get started. I am proud to present to you our two panelists today, Scott Anderson, who is a VP of Community Management He works down in St. George, Utah. And then Kari Ross, who works up in Minnesota. She's also a VP of Community Management. So these are two of our high ranked members of our team. And they're both PCAM accredited, which is the highest designation you can get as a community manager. And so they have a wealth of knowledge they're going to be able to share with you. So I'm going to turn the time over to Scott and Kari.
Great, thank you. We appreciate it. Well, we're glad you guys are here. Scott and I know that this topic is something that either gets talked about too much or not enough. But we know that there's varying degrees of your background of this topic. So we are going to do some kind of 101 information about governing documents and go over some basic knowledge, but we're also going to give you some case studies and dive a little bit into things that may come up regarding your governing document. So we're hoping that you're able to glean a few little nuggets out of today's webinar that are helpful to you. And there will be a Q&A at the end. So if there's something that is you have a burning question about that we don't cover, at the very end, we will be able to address anything that comes up. So today, governing documents. So the one thing that every single HOA has in common is you have governing documents. You may be operating in various states. You may have varying degrees of your documents, but every HOA has governing documents. And so that is, we like to joke about how every single HOA is unique and different. You're all just a big pile of unicorns that are unique and different, but you do have in common that everybody has governing documents. So today we are going to go over what that looks like. We're going to be covering what you're subject to as far as federal and state laws, what your plat is, what a declaration is, what it means to say that we have articles of incorporation, your bylaws, and rules and regs, and what that means. So with all of those things, we have a hierarchy. So the closer you are to the top, the greater the authority that you have. So at the very top, you'll see that laws and statutes, so federal laws and state laws, county or city ordinances, all of those things are at the very, very top. Then you have your plat, then your declaration, your articles, your bylaws, and at the very, very bottom, your rules. So with any decisions that you're making or anything, any ways that you are interpreting your different pieces of your governing documents, you need to always keep that triangle in your mind as far as what holds the most weight. So think of it that way. So thank you. We're going to pass it to Scott from talking a little more about federal laws affecting associations.
Yeah, thanks, Kari. So federal laws are at the top of the pyramid. Those are the ones that we need to pay attention to, and they affect governance within the associations in various ways that aren't always dictated directly in your declaration or in your bylaws. The ones that impact HOAs the most are the Fair Housing Act. If you are in a deed restricted association, age restricted association, that falls under fair housing. This is where we get service animals and emotional support animals, and also reasonable accommodations for people that are asking for the association to do certain things, whether it's add a ramp to their home or make some modifications to the amenities based on a medical condition or some other considerations. That also plays into ADA, the Americans with Disability Acts. And then as far as collecting assessments, we have the Bankruptcy Code, the Service Member Civil Relief Act, as well as like things that affect satellite dishes, because everybody loves satellite dishes. Got to have ESPN and HBO, right? So over-the-air radio transmission devices, that's a federal statute that really impacts how associations can limit or interact with satellite dishes as your owners are making those requests. So One thing to note, this year is a little bit unique where all 50 states of our great nation are in legislative session. And so they are actively discussing and looking at statutes on a state level that will impact your association. This QR code, if you scan this QR code, will take you to Community Associations Institute website, which is our national trade organization, where they are tracking laws under each legislative session that will impact your association. And so it's a really good resource to be informed, because oftentimes, well, most of the time, based on our hierarchy, so all the time, these will trump whatever's in your documents. In Utah, we had a situation where a law was passed on how we treat solar panels. That was a few years ago, and so we had to adjust that regardless of what governing documents said. So pay attention. Also, look at your local chapter of the Legislative Action Committee. They're paying attention to these statutes. If your association can, please contribute to the LAC and their efforts as they're trying to do their best to look at all these laws, evaluate them, see how they're going to impact, and then move forward and adjusting, working with legislators. So it's a really good resource to stay informed with what's happening in your state and what's going on.
I'm going to give a really short plug here. If anybody is logged in from Minnesota and watching from Minnesota, this is the year to be aware and get active in LAC, in the Legislative Action Committee, to pay attention. There are some really impactful things that are proposed in the Minnesota legislature that will significantly impact management companies, managers, boards, how the operations run within your board meetings, how your decisions are going to be made, and if they can be made. I've, in all my years of doing this, I've never seen a more active year than this year. So I'm gonna just put in my plug for the Minnesota peeps to scan the code, see what's going on, be aware of it, and take action if you don't agree with what they're proposing.
And our friends from Arizona and Arkansas, same thing. Look to see what's happening in your local state, because it's going to impact you. All right, so let's talk about actual governing documents, the ones that are really unique to each association. So with our hierarchy, once we get through the federal and state statutes, the first document that we encounter is the plat map. And this is actually my favorite governing document. I believe it's underutilized. People laugh at me in my office, but it really is the most important, and it carries the most weight for your individual association. So what does the plat map do, and why do we care about it? So the plat map gives the boundaries of the association. It gives the boundaries for individual ownership in community associations, as well as private exclusive use for condo associations. It gives common areas. It lines out the common areas. It gives utility easements. And it's a really easy reference if you're trying to figure out if your roads are public or private. It's a really easy reference to determine where the ownership of those roads are. Is it your city? Is it your HOA? Should we really be reserving for it? As well as, again, those exclusive use areas. So in condos, it will tell you whether it's a private use or a or common. Balconies are typically limited common use if you have a balcony in your condo association. So those things are all important because they line out all those different areas, and then they're further defined in your declaration, which we'll get to in a minute. But one important part, and this is why plat map is my favorite and underutilized, is oftentimes there's a lot of information that is only found on your plat map and nowhere else in your governing documents. Examples of this could be parking assignments. If you have assigned parking in a condo community, they could be maintenance of common elements. If you have a monument sign, your monument sign might not be mentioned in your declaration, but it'll be on your plat, and the maintenance responsibility will be on your plat, or even where that goes and placement, and if there's any sort of easements. And so checking your plat map and checking your plat map notes becomes really important whenever there's a question about maintenance. Where does the common area start? Where does private area start? Where do those things end? And so looking at your plat map becomes really important as we try to navigate some of the interesting questions that come up from time to time. Once we get through the plat map, then we get to the declaration. Like I mentioned, it's the plat map, then the declaration. The declaration, what is the purpose of the declaration? We know it exists, but really, what is the purpose of it? The purpose of it is to set forth the contract between the association and the individual owners. What do we mean by that? We mean that the association is going to provide certain services for a fee, right? Like that's the first part of the declaration. Then the second part is, as an owner, I pay this fee, therefore I'm going to receive certain services, or I have certain rights within the association. And so that's a real boil down. And so we can see it here on the slide. Property rights, the declaration defines property rights, defines conditions, use property, so typically noise restrictions or landscape standards maintaining your lot. How many pets you can have within your home are all sort of talked about within the declaration. And architectural stuff, right? These are all things that are kind of talked about within the declaration. Everybody's declaration is slightly different about what they include, but really that is the purpose of the declaration, is to set forth the contract of the association to the ownership.
So the declaration of covenants can actually go by multiple different names. And so this can be confusing for some people. And depending on where you are in the United States, you hear these words thrown around that are different, all pertaining to the same document, the Declaration of Covenants. Some people out west, I think they call them the CCRs. And that's how they're referred to most common. In some places, they're the declaration, and in some places they call them the covenants, but they all mean the same thing. And so you will see CCRs as a reference even within this slideshow as we are moving forward. When we talk about bylaws and CCRs, when we say the phrase CCR, we're talking about Declaration of Covenants of restrictions and rights. And so that is what that means. We just wanted to make sure that everybody understands that even though you may call it something differently, it is all the same document, and it is the next level down in your pyramid, right above the bylaws, or I'm sorry, right above the Articles of Incorporation, which is the next slide. So in the hierarchy, you've got your declaration, your articles, and then of course your bylaws. Your articles are right in the middle of those three. When I need to reference my articles of incorporation, I am usually, that is where I go to figure out what the actual legal name of your community is. So if I'm creating any sort of a document, even when I'm creating your annual meeting notice or anything like that, and I need to make sure that we're using your legal name, I go to the Articles of Incorporation and look that up. It seems silly, but it is right down to the detail. If there is a, your community is Happy Acres, comma, an HOA or Happy Acres Association or Happy Acres Homeowners Condominium Association, Inc. with an apostrophe under homeowners. I mean, right down to that level of detail is what we're looking for. And what your articles of incorporation do is they help establish what the purpose is of your community. It's what provides your structure, gives the authority or the powers, but it also provides the protection. So this is what protects yourself from individual decisions and options. I'm going to go to the next slide and talk about your bylaws. All right, so a lot of times homeowners call our office and they say, I need a copy of the bylaws. And I don't know if some people like to just substitute or kind of lump all of the association documents into that word bylaws, but bylaws isn't really something that homeowners would necessarily find very interesting to read, because basically what your bylaws do is they establish the rules for how your property operates. It's where I go when I need to understand how many board members I would need to have. Is it you may have 7 board members, no more than 7, no less than 3. So if I am at an annual meeting and I get 10 nominations and they say, well, can't we just have 10 board members? We finally have people who want to be active in our community. Can't we just let everybody be a board member? No, your bylaws tell you that you shall have a certain number as a minimum, or how many there should be. This is where we go to look for what the duties of each officer are, or committee members. It's where we have the authority of whether or not you can appoint someone to be a secretary if they're not an elected director. This is where we would look for that, or what your quorum is. These are probably the most common things that people are looking for. So I have this little thing that I do when I'm training my managers, and even when I'm talking with some of my boards, and this is absolutely to the horror of my adult children, but I have something that I say to help everybody really grasp and remember the hierarchy of declaration, articles, and bylaws, and which one is on top, which one carries the most weight. Remember, the one on top carries the most weight. So we dab. And declaration, articles, bylaws. Like I said, and I literally can't say dab without dabbing. And every time I do it, my kids roll their eyes and say, oh my gosh, Mom, please don't ever do that again, ever. So anyway, hopefully that helps you remember.
I wish I had a
Scott?
fancy dance move to talk about rules and regulations and resolutions, but I don't. But alas, at the bottom, the last governing document that we talk about that probably gets the most conversation during our board meetings and during just disputes with owners is the rules and regulations. So what are the rules and regulations, right? We've talked about the plat map sets the boundaries of the association. The declaration is the contract of the association between the owners. The articles offer some protections to the HOA and offer the legal name to the association. And the bylaws are the administration, how your association is supposed to run. So what are rules? Rules and resolutions are designed to clarify anything that isn't talked about in your association, or that is potentially ambiguous or confusing that the board feels like they need to clarify, right? And so those are like really what we're doing for rules, and they tend to fall into these 4 areas: general routine events. Sometimes in your documents you'll read that the budget must be approved by resolution of the board. Oftentimes that doesn't happen. It's generally just in the minutes, but that would be a resolution for general routine events. Administrative policies are a resolution. So if you have a late fee collection policy, how you're treating accounts that are delinquent, that would be an administrative internal operation that is adopted by resolution. Typically in the documents we read, the association shall charge a late fee on assessments that are delinquent, but they don't tell you what to do after that. And that's where the resolution comes in, is to deal with the after part. And then you have special resolutions. If an owner has been granted a variance for whatever reason, those should be documented in a resolution. And then again, the policy rights and owners. These are typically amenity use situations. If you have a pool or a tennis court, what's the hours of operations, what's the key fob policy, those sorts of things that aren't explicitly laid out in the declaration. And so as you deal with you when you grapple with some of these issues, right? Start at the top and work your way down. And if you don't find the answer to what you need, if it's not explicitly in the declaration, if it's not explicitly in the bylaws, then we can address it through the rules making procedure. And different states have different operations on how you pass those rules. So it's really important to make sure that you're doing that correctly. If you have questions about that, reach out to your manager and they can help walk you through that process. So what we sort of polled our office on what we want board members to kind of take away from this discussion and governing documents. And their answer was, we want boards to actually read them, right? And we say that a little tongue in cheek, but sometimes we run into issues in board meetings where they're discussing things like special assessments, and they're like, hey, we want to pass a special assessment with no notice. And we're like, well, you can't do that because your documents address the notice requirement, how it's supposed to be divvied, what payment options you have potentially, and they address some of those things. And so making sure that you are at least familiar with your documents and that we go back and reference them as we walk through some of these complex issues is really, really important, that board members take the opportunity to understand what the purpose of each of those are and what's in them for your individual association. So, resolutions. So we're going to talk about resolutions a little bit. And so, I think I'm a little bit behind, but right. So, resolutions, if you are addressing resolutions or trying to put resolutions, here's a simple acronym. People all should ski. If you're in closer to the beach, people all should surf. If you're in Minnesota, people all should snowmobile, whatever that happens to be, right? But if you take a CAI class, they call it PASS. But these are the things that all resolutions should have. They should state the purpose, authority, specifics, and scope. We'll look at this a little bit later, but when you're talking about resolutions or developing rules, make sure to keep these things in mind. Even when you're looking at your declaration and your bylaws, keep these things in mind, like what's the purpose of it, what's the scope, where's the authority come from, type of thing, as you work through that.
So now what we're hoping to do is we're going to dive a little more into case studies. And so the following are real examples that we think are going to help board members better understand how to read and how to understand your governing documents. We also want to be able to provide some options to consider different situations that you may encounter. So the first example is intentionally general to show that not all governing documents are clear. What? Shocking, I know. But yes, that is the truth. I don't know how many times a day I actually hear from either homeowners, board members, or from a manager, I need some help interpreting this. This doesn't make sense, or this isn't clear, or what. So we just want to be able to show some examples of things that would be good examples and maybe not, and then what we can do about it. So this is probably one of the most common things that comes up is maintenance. And an example of a covenant or declaration that regards maintenance, that is a very good example that really outlines the detail of exactly what is covered by the association and what is homeowner responsibility. So this particular example that we are looking at today shows that it's very, very clear about what the association is responsible for and what the homeowner is responsible for. As you notice, it talks about, and let me just give you a little hot tip for everybody in our industry. We always are looking for two words, may and shall. May means there's a little leeway, there's a little flexibility. Shall is a hard stop. That is, if it says shall, that is what shall happen. There is no option. But if it says may, then that does provide a little bit of a gray area in what a board can or cannot do and how things may be assessed or handled. So in this particular example, starts off right away at the beginning. Each owner shall furnish and be responsible for, at the owner's expense, all of the maintenance, repair, and replacement of all fixtures. And I'm not going to read it all the way detail word for word, but I'm going to skip to where it lists out specifically each item that it covers. So all interior doors, exterior doors, garage doors, including door trim and door glass, all paneling, tiles, wallpaper, paint, carpet, finished flooring, and any other materials constituting the finished surfaces of floors, ceilings, or interior walls. All windows, window frames, and trim and door glass. That's very, very specific. And then it goes on to talk specifically about things that are either inside or outside of the unit. And so we love this example of a governing document where it's pretty clear on what would be covered and what would not be covered by the association. We'll go to the next slide and look at an example of the gray, the ambiguous. So this is one where there's just not a lot of detail. There's just not a lot of information here. And when it talks about doors and glass, it doesn't really give a whole lot of information about whether that's the interior or the exterior. Surfaces, think about that. How ambiguous is that word? Windows and frames, utilities, appliances. It's just, there's a lot of room for interpretation with this. We don't like this example. And we would say, what would you do with this? How can we fix this? So our suggestion would be you can either amend your documents or you can adopt a resolution. These are board options to consider. And what you do when you have an area that's vague. So let's move on to the next slide.
So we often get questions about when should we amend our documents or how can we amend our documents? And we're going to give you the legal answer. The legal answer is it really depends. If we look at the next slide, when you're evaluating your governing documents, here are some key aspects of when you really should start talking about amending them. When they're outdated, do you have documents that are from 1987? If you have documents that are from 1987, they're really old. They don't have the new statutory requirements. The nature of your association may have changed. How you're enforcing some of the rules may have changed. And so you need to bring those documents up to par with what's actually happening in your association, as well as address those statutory amendments that happen on a fairly regular interval, excuse me. And then when change is reasonably justified. If you are going into your annual meeting and you have a quorum requirement of 40%, and it takes you 5 times to get quorum requirement, there's a conversation that needs to be had amongst your association of either one, how do we encourage more involvement, or 2, should we lower that quorum requirement in order to be able to transact business and not hold up the administration of the association? As well as, right, like, again, like if your nature, like typically around parking, trailers, if you have more people moving in with trailers and your documents don't specifically address that, hey, you may need to address that issue. Or solar panels, like I mentioned earlier, when you're talking about some of the newer stuff that may not have been contemplated in 1987, then we need to kind of address those things. And then when there's disagreements between the CC&Rs and bylaws, we've seen documents where, we like to call them the Franken documents, where declarants have taken bits and pieces from different associations and just kind of stuck them together, and they may or may not be in harmony with each other. Like your CC&Rs may say you can only have 3 board members, but your bylaws say you can have up to 7. Your CC&Rs are going to supersede and only allow you to have 3, but your bylaws need to be amended to match that, or you need to amend your declaration to increase the number of board members. So if you see conflicts between the documents, you need to do an amendment. Consult an attorney. When you go to an attorney, make sure they're an HOA attorney. Having somebody that understands the industry and what you're dealing with as a board member is super important. And so, right, like when we talk about amending documents, there are challenges. We're not naive in saying that there's not challenges. It can be expensive. There are some legal fees that involved with drafting the documents and sending out ballots and holding meetings and all the things, as well as your documents require a certain threshold in order to pass those amendments. And so when you approach an amendment, you really have to talk through all of those things and strategize and make sure how you're going to attack that. And then at the bottom here, another option is, can you address that through a resolution to try to clarify those things? Excuse me. And so those are some options there. And so here's an option where a resolution kind of solved a problem. So 2 adjoining associations had some common area that was on a plat, and there was some question about whether or not who was supposed to maintain that portion of common area. We looked at the plats. The plats said general landscape area. There wasn't anything specific that said, hey, this association maintains this association maintains this. And so we started to go through the documents and draft this resolution, draft a maintenance agreement between the 2 associations. And so remember our acronym, PASS, purpose, authority, scope, and specificity. You can see these on the side. So the authority is those first bullet points that indicate in the documents where we're pulling the authority in order to do this. And then bullet point F is the purpose of the resolution, to clarify those maintenance responsibilities between the 2 associations. And then if you go to the next one is the specifics and the scope, right? So the scope being this agreement is going to stay into effect until it's changed or repealed. And then the specifics line out what the maintenance responsibility is between those 2 associations, how they're going to deal with that combined common area. And so this is an area where, like, there could have been an amendment to the plat, but that would have been really expensive and cumbersome. So instead, there was an opportunity to clarify what those maintenance responsibilities were through a resolution. And so resolutions become a really powerful tool. And again, clarifying things that are intentionally or unintentionally vague within your association. And so here's another one. Chickens, right? I'm sure most associations have dealt with chickens on some level. Backyard farms are gaining popularity. And so with questions on how to deal with chickens, it comes up. So again, we have to go back and look at the hierarchy of documents. So where do we start? So we start first with looking at city ordinance. If we go and look at the city ordinances, this is what the city ordinance is. Does your local municipality even allow backyard farms? Like, that would be the biggest thing, right? And so in this case, this municipality does allow backyard farms, chickens within an association, as long as they meet certain requirements of lot size and a few other things. Here it says house cats, cages, pens, coops, etc. shall be provided for animals kept outdoors, right? So there's some indication that the municipality allows chickens, right? So then we're going to look at, I got ahead of myself. All right, so now we're going to look at the actual CC&Rs here. This is what the CC&Rs say for an association. It says commonly accepted household pets in accordance with city ordinance. Well, we know city ordinance already allows chickens, but the question is whether or not they're commonly accepted household pets. I could argue because of the prevalence of backyard farms, they're commonly accepted, right? It's more of a conversation. And so there's another provision within the documents that says, hey, no noxious or offensive activity is permitted that disrupts neighbors or is an annoyance or nuisance to neighbors. Obviously, that is a concern, right? So we have to take that into consideration of what is happening. And so here are some other provisions within the documents that say, hey, the board has the opportunity to adopt, amend, or repeal rules and regulations. So they can change some things based on the requests and ownership of the association. And so we'll adopt those through the rules, so they have an opportunity to do it. And then the board also is granted the right to interpret the declaration. This is a specific right within the declaration that the board has that opportunity. So, right, the board can interpret the declaration kind of how they want in accordance, and they may need to adopt some rules in order to reflect their decision. And so we also have ARC guidelines that they, if somebody's asking for a coop, it's got to go through the board to review what that looks like, how that may impact owners, and look at all those different considerations that the board may have. And so here's a real super quick summary. City allows chickens. The city requires that it has to be outside. The city does not prohibit the types of pets. The association documents don't clearly define what the pets are, but we know chickens may be an annoyance. So what are your options at this point? Your options at this point are you can look and default to city ordinance and say, hey, city allows chickens. We're just going to allow it because we're not super vague, right? Our documents are super vague. We can just default to the city and let them take over. We can get a legal opinion from an attorney and say, hey, this is what we know. This is what we're thinking. This is what we know. Give us your legal opinion based on what you see. And then based on that, or you can look at the documents, make your best determination on what you think the documents are trying to say, and then clarify that through a resolution, and then communicate that on to the owners. So you have some options. What did the association do in this instance? The association in this instance went out and asked for a legal opinion from an attorney and basically said, hey, this is the request, this is our documents, this is what city ordinance has. And so here's the legal opinion from the attorney. It's supposed to be kept. Well, this is the legal opinion to the board on how he's not saying what to do. This is based on what his opinion. So take his advice and decide what to do. So the association clarified this opinion, and said, hey, it's our opinion that the documents intended to prohibit backyard chickens. So if you want to prohibit backyard chickens, you have some legal standing to do it. If you want to allow backyard chickens, then we probably need to do some amendment to your documents and then to allow that. And so this particular association prohibited backyard chickens because they were concerned with the noise, and then they communicated that on to the owner. And so that's how those documents all kind of work together in this case. So, water heaters. This is a case of like stacked condos, where water heaters, if you're in a if you've ever lived in a stacked condo or an apartment building, generally there's something that happens on the top floor and it filters all the way down and it causes a whole bunch of problems. And the maintenance becomes a question on whether or not how to deal with that, because the association is concerned about insurance claims and different things that they need to take into consideration. So here, frequent water leak, damage has occurred in neighboring units, damage has occurred to common areas. Can the association start maintaining? Because they're like, hey, we're tired of dealing with this. Owners are complaining all the time. Can we take this ownership on? And really, should the association take that on is another question. So let's look at this one. So in the documents, it specifically says all the sewer, drain pipes, waters, water lines, and other utilities are the unit owner, and they specifically call out water heaters are the owner's responsibility. In section 4.4 of these documents, it does say that the association shall have the right, but not the obligation, at the expense of the owner and without liability of the owner, to trespass and otherwise and take corrective action that the board deems necessary. So it gives the board an opportunity. If they're like, hey, you're not properly maintaining your water heater, we can go in and fix it and we're going to bill you for it. That causes some problems, I will say, but at least that authority is there. And so we can look at some of these other ones. And also within maintenance, it says if, excuse me, the need for maintenance and repair is caused through willful or neglect act of the owner, the board may cause the needed maintenance or repair to be made. So in this particular association where leaks are kind of all over the place, can or should the board be able to take over that? These documents grant the board that authority to be able to take corrective action on a one-on-one basis. Whether they should do it all together is a greater conversation, because what does that do? That creates a financial obligation for the association. So here's a summary. So owners are required to maintain their water heaters through their documents. The association is required to maintain the common area. The association has the right but not obligation to take corrective action, and the association can bill the owner through repairs. And if the appliances serve in multiple units, the association may take that on. So that's sort of what we know. And again, I'm going to caveat this before we get to the next slide, but it really depends for your association what the correct approach is for your association. You have to understand your owners, your association, on what you need to do. So if we look at the next, so when you decide, before we jump into this one, before you decide, you really need to understand how your owners are going to be impacted, and then you can make a decision and you can follow that by resolution.
And that's a great segue for the next topic, the next question that has come in. And these are actual scenarios and questions of things that have come in that we deal with. And so snow removal. I mean, obviously that is a big topic for us here in Minnesota, but I know also in parts of Utah as well, and not so much in Arizona, hopefully. But so here, this little request that we got has a couple different things that I want to point out. First of all, it says when we bought our home, we were promised we would have snow removal handled for us. My first question is, who promised you that? Did your realtor tell you that you were going to live in a maintenance-free home? One of the things we like to tell our homeowners is the only kind of maintenance-free living is at a nursing home. If you are living in an association, that does not mean that your life is going to be maintenance-free and you don't have any responsibility inside and outside of your home. There are definitely things that you may need to have still in your arsenal of tools as a homeowner, and a shovel might be one of those, even though most people like to move into an HOA because they don't want to shovel snow or don't want to deal with it. It's not guaranteed that in every single HOA, snow removal will be part of their services that are offered through the dues that you're paying. So when we go into the declaration of covenants and look at this specific association, it says that the association shall maintain, repair, and replace any and all common areas, including without limitation any roads within the community that have not been dedicated to and accepted by the city. And it says that the association shall maintain all landscaping and plantings. What words are missing from that section? Snow removal. It's not mentioned. It does say that they will repair and replace as necessary. And it doesn't say that they will maintain all landscaping and plantings, but it doesn't specifically say that they will remove the snow from your driveway or from anything. So if we look down under the assessment section in 11.02, it says that they may include other things like expenses of snow removal. That may be something that would be covered in your assessments, but it doesn't say shall. So there's no guarantee that that is something that would be covered. If we take a look at the summary of this interpretation with this specific scenario, yes, the association is definitely required to maintain and repair the common areas, but they're not necessarily required per the governing documents to remove the snow. Now, that may be something that the board opts in to do, just because it might just be the right thing to do, and you raise dues to cover those snow expenses. But if it's not necessarily required, there also may be very specific rules or contracts or factors that homeowners haven't paid attention to that have to do with this particular thing. I live in a townhome association. I have 2 vehicles and I have a garage, but my garage is full of my children's items that they haven't collected yet. I'm storing them for them. So I can only get 1 car in my garage. So I have to park a car in my driveway. This precludes me from getting snow removal services. I know that because in the rules in my association, it specifically says, if you have a car parked in your driveway, you will not receive snow removal services. So I knew that going into it, I was going to have to be shoveling. So yes, I live in a townhome association, and doggone it, I am shoveling every single time that we get snow. And that's just, it's a bummer for me, but I knew that going into it. So it's really important for homeowners and everybody to really read your documents and be aware of that going in. And so for this particular situation and scenario, well, the board can decide, yeah, do we need to provide snow removal because it does help the overall picture of maintenance and repair. Something to consider. If you don't already have snow removal in your budget and you're not budgeting for that, adding a contract in for snow removal is going to increase your expense budget, and that we will show next, but that is going to have to increase your dues probably. And so you can see in this particular scenario that, if you aren't currently budgeting for snow removal services and you were to add in a contract for that, it's definitely going to impact the bottom line. And so for an association like this, where they have the option of snow removal or not, if there are financial concerns or there's a reason why they wouldn't want to have dues increased to cover those services, and they have the authority to not have to cover snow removal services, they could remove that from the budget, save a lot of money, and not have to raise dues. Depends on your homeowners. And I know we sound like attorneys when we say that, but it is so true because every single community is different and every set of documents is different. So you have to consider all of those things. Okay, this one's my favorite. So this was actually my community that I was managing. And basically, in reviewing their documents when we started managing them, I was reading their bylaws, and right away in the very first paragraph, it talks specifically about them being HOPA, being 55 plus. Also on the welcome sign coming driving into their community, this big, beautiful welcome to our community, it says a 55 plus community. So I'm thinking, okay, well, great, that we know that there's that's who they are, But once I continued reading and got into their CCNRs, you go to the next screen, you will see that nowhere in their declaration does it mention that they are a HOPA, which is the federal program that Scott mentioned earlier, that they are a 55 plus community. Remember, DAB, declaration, articles, bylaws. Declaration carries more weight. The bylaws might say that they are 55 plus and subject to HOPA, but their declaration does not say that. So they were not officially a HOPA community. They had been operating that way. Their welcome sign said it out front. Basically, they'd just been discriminating against every homeowner who tried to buy a house in there for the last 25 years, telling them that they had to be 55 plus to live there, but they had no authority to do that. If you look specifically at their definitions of who they were, they are a single family residence. That is, they're located, that's how they define the word dwelling. And in the units, it says that they are restricted exclusively to residential use. Okay. But if you look specifically in their bylaws, right away in the very first paragraph, it says they shall be designated as housing for older people, HOPA, at the HOPA Act of 1995. But they weren't. Legally, they were not a HOPA community. So this was definitely a quandary for them. And I had to point this out to them like, hey, your declaration, which is higher than your bylaws, DAB, does not say that you are HOPA. So now what do we do? So really, if they wanted to stay a HOPA community, the only real option for them was to amend their documents. They had to amend their declaration in order to bring themselves into compliance and to match where they were different between their bylaws and their declaration. That was a decision that they had to make. If they decided that they didn't want to be 55 plus any longer, they could change their welcome sign and do a resolution to change their bylaws. But if they wanted to become HOPA, they would need to amend their documents and absolutely get a legal opinion.
So what are the recommendations from today? So there's some case studies that we can see how the documents kind of work together. And this is really the process when you ask your community manager some questions. Like this is the process that they are kind of going through before they provide any recommendations to the board. So how do we do that? So we need to read and get to know our governing documents. We need to consult resources when considering changes, whether that's an attorney, whether that's fellow community managers based on their experience, and community feedback. Are you doing surveys on rules that you're proposing to adopt or even amendments that may be needed in your association? Are you soliciting feedback on what you can and can't do? Remember that you need to comply with the hierarchy of documents that, you know, as Kari pointed out, that we all dab in our board meetings, and remember the declaration and how that all kind of plays together. And then enforce that the association value depends on consistent and unbiased enforcement of the rules. That when questions come up and you give an answer to an owner that they don't like, but it's based in the documents, they need to be okay with that. They may not be okay, but they need to at least understand that, hey, we don't have anything against you. Like this is what the documents allow. And there's a process to change that if needed. And then communicate and share board decisions when those things come up, like the chickens or snow removal. If you're adding or taking away services that the board has options of, make sure that you're properly communicating that to the owners to make sure that they understand kind of what's happening within the association and why those decisions are being made. And so those are some recommendations.
The only other thing I would add is consistency. I think that's one of the main things that I like to tell my managers that they advise their boards is be consistent. Don't pick and choose what rules you're going to enforce. You're going to enforce rules, enforce all of the rules, not just one or two. It's not an option. You're going to be accused of discriminating. They're going to be accused of all different kinds of things. You've got to be careful with that. Tread lightly. If you're going to handle maintenance the same way for one owner, then you gotta handle it the same way for the next owner. Board members don't get preferential treatment. Your neighbor who you love next door doesn't get special treatment, but the guy down the hall who's super annoying and, irritates you when you pass him in the hallway, he gets different treatment. No, no, no. Consistency. You treat everybody the same and you enforce everything consistent with your documents, with federal law, with state law, with city ordinance. That's the number one thing that I like to tell everybody is that is the key to not getting yourself into trouble or getting blamed for things.
Staying off the
So.
5 o'clock news, which is a goal of all of ours.
Yeah,
right?
That's always our goal, right?
So that's our presentation. I'm sure there's some questions that we can answer and hopefully lend some thoughts to that. Do we have any questions?
So it looks like we don't have any in the Q&A right now, but if anybody does have them, oh, it looks like someone just submitted them. You can do that or raise your hand. Thank you, Patty, for that. She said it was very good and clear. We did have somebody email in a question before the event. And so I wanted to play a little bit of a game. Didn't talk to any of you guys about this, so keeping you on your toes. I obviously work for HOA Living. I'm around HOAs. I live in an HOA, serve on a board, but I am not a community manager. So I'm going to take what you guys talked about today, and I pulled up the documents for this association to see if I've done it right. So the question is, for the past 20 plus years, this condominium association has always repaired, replaced driveways, sidewalks, from driveways to the unit, and their balconies, porches, and patios. They are feeling like in their governing documents, it does not say that that's a requirement, that it's the individual owner's responsibility. So I pulled up their governing documents, started with their declaration, and went through to see what is defined as common area, what's limited common area. And then to Scott's point about the plat map, which I haven't really looked at, I pulled up, it really depends on where they are, because looking at their map just from the beginning, it looks like it's possible these are limited common areas. Are you guys seeing my screen?
Yes.
The plat
Yep.
map? Okay, perfect. Thank you. And so it seems like the question is, do they fall into limited common areas or common? And from this quick glance, it looks like not. However, in some of their rules and regulations that they have posted, it is really confusing and not clear. And it looks like they've kind of taken that responsibility on. So I would guess that the recommendation would be confirm that it's really common area and they're responsible for it. If it is limited common area, then clarify that through a resolution and maybe have a responsibility chart that outlines what each association is responsible for. So how did I do? Can you grade me? Am I off base?
Yeah, you did great. I give you
Awesome.
an A-.
Yep.
Right? Like,
So what else do I need to do?
looking at the maintenance responsibilities, what the language actually says, right? Because sometimes the language is really super important and how we interpret what that language actually means. For example, sometimes we get language where it's like, hey, the owner's responsible for maintaining this in a clean and sanitary condition, right?
Yes.
So the documents say maintain in clean and sanitary. What it clearly does not say is replace. Right? So we have to look at what the word, like what it actually says, because that may determine how that goes and how your resolution is going to be formulated, right? Like, hey, the maintenance of, like, the association will replace whatever is broken, but the owners are responsible for maintaining what the association puts in. Does that make sense?
Yeah, no, that's
Yeah.
great. So I guess to this individual who asked the question, I did loop your community manager in, so I would talk with them a little bit further and just really clarify that. And then it looks like we do have some other Q&As. Let's see. Our association pays fees for retaining an attorney, and they're wondering what that legal service provides when there's retaining an attorney. So I'm assuming if they wanted to have their governing documents reviewed, is that something with the retention? How does that work?
That would be, and Kari, you can chime in. That would be based on whatever the specifics of that retainer is with the attorney. typically, if you have them on retainer, it's for day-to-day legal counsel on, hey, owner disputes, or hey, clarify this one section of the documents, not do a complete rewrite. That's typically falls outside of the scope of retainers, but it really depends. Again, my nice attorney answer, it really depends on the specifics of what that retainer agreement is.
Yeah, it's usually for something really specific. It's not that I don't know an association that can just afford to keep an attorney like on staff with their like on a retainer, like all the time for every single thing that comes up. That would be unreasonable. But if you maybe, I don't know if it's confused where you have an attorney relationship with somebody who you can go to and ask questions to, because that might be what you're confused with, as far as it could be a retainer for a specific thing, or it could just be that you have an attorney who you use as an advisor, and who you've gone to for different opinions and different, brought them in for different things. So.
Awesome, thank you. We have a couple other questions I might individually reply to, but Oscar asked about being a new board member. He's the treasurer and he wants to know what he should focus on. We have a AES playlist of all of our 101 series. So I'm going to drop that in the Q&A so you guys can grab that. We'll also send out an email following this event with the recording and link to the slides, so you can have that.
One thing I'll note on this is we kind of talked about for the treasurer, look at the assessment sections of your governing documents and what it says the assessments are for, to make sure that you're meeting those obligations and how the assessments can be raised. Typically in your documents, there's a cap on how much you can raise each year. If you have any special assessment considerations. So look at those assessments and become familiar with it. Obviously, as the treasurer, you're more financially minded. So that may pay particular of interest for you, looking at those sections and understanding how that works. So when your manager's like, yo, hey, we need to raise the fees, you can see where they're coming from or how that process can work. And then you can kind of help that process along.
Also go to your bylaws and look under board of directors and the officers and what your job description is. There should be somewhat of a job description in the bylaws under treasurer, or there could be, that tells you what your duties are as treasurer. So there's also within your state statutes, there might be some helpful tips, or go in there with information about what your duties may be for each director, and each officer.
Awesome. Well, it looks like we've answered all the questions. Like I said, there will be an email following this event. If you have any other questions, please feel free to reach out or contact your community manager. And typically I'd have Darren do this, but I can't stop talking. So thanks for listening to me, everybody. But Kari and Scott, you guys are such a wealth of knowledge. Really appreciate you guys sharing. I think it's been helpful for me as a homeowner in an HOA, but also to be able to help other customers. So thank you.
Awesome. Thank you.
Thanks, everyone.
Thank you.